Hi, I'm Heather Boyd. Welcome to another edition of IP Somm. Today, my guest is Michelle Lacroix. Michelle recently wrote her trademark agent's exam, and she was notified in March that she passed. So I'd like to congratulate Michelle on becoming the newest trademark agent with Pillar IP. Michelle.
Cheers.
Cheers. I wanted to talk today a little bit about what it is to be a trademark agent, what that represents, the difference between a trademark agent and a lawyer, and why it's important for you to hire either a trademark agent or lawyer to represent you in protecting your trademark brands in Canada and, in fact, worldwide. So let's get started with that. Michelle, why don't you tell us a little bit about what you had to go through to become an agent?
To become an agent in Canada, you have to practice under a registered agent for at least 2 years.
And that was me.
That was Heather. She did a wonderful job. So you have to be learning about IP from someone who has been a registered agent for a number of years. You have to study a lot. And they issue an examination once a year that you can write. It's a 2-part examination. And you write both parts in the same day. And
which they didn't do when I wrote my exams. When I wrote, we did one day of basically on the Trademark Act, and the second day was oppositions and the actual implementation of the law kind of thing.
So the exam is notoriously difficult. It's a lot of pressure to be put on to spend 2 years studying and then have everything come down to one day. It's about 6 hours of writing, and you write and then you keep your fingers crossed for about 3 or 4 months. And then you get a letter in the mail out of nowhere advising if you've passed or not. And I was fortunate enough to pass this year. This is really important because all of the laws are changing in 2 months' time.
Yeah.
So it was really important to get in under the old laws because the people who have to write the exam next year it's completely different.
They have to know the new law, which is going to be hard if they're not practicing in it.
Well, and a lot of the case law is out the window now as well.
I want to emphasize that Michelle writing the exam and passing it on her first try is really something that needs to be commended because it is such a difficult exam. And Michelle primarily has been working with patents for the past 15 years. So that makes it even more difficult when you're not actually embedded in trademarks to be able to write and pass it on your first go around. Michelle, do you know how many people passed?
No, they haven't released any of the numbers.
Will they release that?
The last numbers they released were for 2017, so we actually didn't get the numbers for 2018 either.
Okay.
It's usually part of a EPIC course that's offered where they'll give you those numbers, so I probably won't get them because the course is about $2,000.
So in 2017, what was the median pass rate, or do you know?
I think it was about 11%.
So when I wrote it back in 2003, the median pass was 3%. So it's improved a little bit, and I'm not sure if that's because of the marking.
Well, I think it's dependent on the year of the exam because we received 5 years prior of exams, and it varies from 3 or 4% up to actually 22%. So it really depends on who's writing and who's marking the exam for that year.
So you know that when you have a registered trademark agent, that they've gone through a lot and they actually know their stuff. They have to know it in order to pass it. So that brings me into the next part of our discussion in talking about the difference between a trademark agent versus a lawyer. Lawyers can be trademark agents and trademark agents can be lawyers. But in order to be a lawyer, you obviously have to go through 4 years of school, plus do your bar ads, and do an apprenticeship kind of thing with a law firm. So we've taken a little bit of that away from the trademark agents, in that you don't have to write any bar ads, or I guess the equivalent is the trademark agent's exam is the bar ads, but you don't have to go through 4 years of education to get this. You do 2 years on the job training kind of thing in order under a registered agent before you can write. So
the concept of working under an agent is similar to articling in the lawyer sense. And it is worth noting that lawyers still have to write the trademark agent's exam to become a trademark agent as well.
They do
One
now.
does not automatically mean the other.
Right.
It hasn't in
So,
many years.
so when I wrote, the lawyers did not. I think it came into effect a couple of years after I wrote the exam. Up until then, lawyers, all they needed to do was sign an affidavit saying that they had trained underneath a registered agent for 2 years. So they didn't have to prove that they'd actually worked in it. They just had to say they worked alongside an agent and were familiar with everything. So they changed that a few years ago because they were finding that there was a lot of lawyers who were practicing trademark law, and they just weren't doing their clients any favors.
Well, it's this idea of having a general practice lawyer who can practice family law and corporate law and trademark law. So you're not really an expert in any field. You have a general knowledge of a lot of fields, but for your IP protection, maybe that's not the strategy you want to take.
And I liken it to, you don't go see your general practitioner to have your tooth pulled. You go see a dentist. So there's different type of schooling, there's different type of focus, specialization, and that's what trademarks are. Trademark agents are in relation to the law. So let's talk about that. Being an agent, a registered agent before the Trademarks Office means that we're we're registered to practice before what we call the Trademark Tribunal. So this is the Canadian Intellectual Property Office that has factions of it. So there's where we file the application, that goes through the registrar, and then there are two other kind of litigation factions of the Canadian Intellectual Property Office in relation to trademarks that we can practice before, and that's the Section 45 and the Trademark Opposition Board. So Trademark Opposition Board, it's like a mini
trial,
a litigation kind of thing. We should actually introduce our drink here. So today Michelle and I went to Spain a few years ago for a conference, and we found a mutual love of gin and tonic. So today I made us some gin and tonic made with it's a 66 Gillied distillery gin called the Loyalist. It's Loyalist gin. Plus their tonic water. And then we had to add a little bit of the agave syrup because I'm not sure that the tonic isn't maybe past its prime. Gillied 66, it's no longer called that. It's a distillery down in Prince Edward County, and now it's called Gin Sip. So shop local. Cheers! I do like gin and tonics. We threw a nice little lovely sprig of rosemary in there. So there's some golden berries, lime juice, lemon juice, and again we've used the Esca lemon sparkling water. I actually prefer using tonic drops that you add to a sparkling water because there's not as much sugar concentration as a regular tonic water that you would buy from the grocery store. That's my little spiel. We're going to continue to drink while we talk more about becoming an agent, being an agent, and what that means to you. So we are not lawyers. Pillar IP, we do not employ any lawyers in our firm or our agency, but we can practice before the Trademark Tribunal. So I like to say we can play them on TV, but we are not lawyers, so we don't provide that type of legal advice at all. We only provide legal advice in relation to trademarks or the IP, depending on the agent that you're speaking to, because we do have a couple of patent agents on board as well. Today, Michelle and I are going to talk a little bit about why it's really important to hire a trademark agent or a trademark attorney in order to prosecute your trademark application through to registration in Canada. Michelle, what's your primary concern when somebody comes to you and asks about a trademark application or registration?
Something that they've already filed?
Yeah.
Usually if an applicant has filed an application themselves, I'm afraid that they've filed using the wrong filing basis, which can lead to invalidation of your registration. And
we've seen that a lot. Applicants, we've had one where an applicant filed based on proposed use, but they'd been using it for a number of years, which in Canada, will it change after the?
It will.
Yeah.
So after June 17th, all the laws are changing, and you will not have to state a filing basis. So you won't have to state if your application is based on proposed use or if you've been using it prior to the filing. But until that date, having a wrong filing basis can be fatal to your application.
We've had a number of clients that have come to us and they've put in an invalid filing basis. That may not have an effect on them after June 17th, but prior to, it is one of the main criteria that third parties will use to challenge an application or for registration. What else have you seen with people who have filed on their own behalf?
Mm-hmm.
What the problems they're encountering?
A lot of people aren't really familiar with how the Trademarks Office wants to see the lists of goods and services in an application, so they receive a lot of objections based on that, where the office is requesting that they reclassify their goods or services, or they want them in what they consider ordinary commercial terms. So what somebody who owns a company thinks is ordinary to their business is an ordinary term. The Trademarks Office can look at that and say, we have no idea what this is, or it's too broad, you're going to be granted too broad of protection. And they receive what's called an examiner's report from the office, and generally the applicant doesn't know what to do with this, doesn't know how to respond to it, and that's when they reach out to us a lot of the time. Other issues I've seen is applicants will file in their own name because they don't want to file in the name of their company, even though the company is the one who's using the mark. There's all sorts of issues.
Yeah. My favorite one is seeing the application where they filed for their trademark, and then they put the wording of the trademark. They say, for use with blah, 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 which means that the trademark that they're claiming they're using has all this additional wording. Mm-hmm. And the Trademarks Office will not allow you to get rid of that wording after it's filed, so that it's just your trademark that you're looking at. So it's there. Like I said, there are some nuances when filing the application that not everyone is really familiar with. But I mean, that's not to say that people can't file applications on their own, but when they run into problems, we tend to get a lot of questions about them.
Another good example I've seen is applicants who file a logo mark and they don't really understand the marking laws in Canada, and they've been putting an R in a circle on all of their marketing material, and which you can't do unless you have registration. And they will file an application and upload an image of their logo which contains the R in a circle. So obviously that's not going to fly. You're filing for a trademark application with the registered mark logo within it, and you don't have a registered mark. So
the R in the circle is the symbol that designates that it is a registered mark. So that your ultimate goal when filing an application is to achieve that R in a circle symbol. But that can only be granted with a registration certificate from the Canadian Intellectual Property Office. So if you're marking it with that R in the circle before you have a register, but in other countries, if you were to do that, it can be considered a criminal offense. So be very careful, especially if you're exporting goods without having registration in Canada, and you've got that R in the symbol. If you're exporting them to the US or something like that, it can create huge problems for you. Then it's considered fraud. Now, in Canada, they tend to just kind of do a slap of the wrist, take it off kind of thing. So the importance of hiring either a trademark agent or a trademark attorney or lawyer is to make sure that your application goes through in kind of a fluid manner. We can guarantee that the applications will be filled out accurately and in such a manner that they will be issued the proper serial number, filing date, and eventually go through to registration. It's also really important to use a trademark agent or a lawyer in order to do a search prior to filing your application or before you even use the trademark in Canada. Mm-hmm. Michelle, why is that really important?
You don't want to be infringing on somebody who has prior rights. We do a search of the Canadian Intellectual Property Office's database as well as a common law search. And the importance of doing a search is if you're not aware of a company on the other side of the country who has registration for the same mark that you have for the same or similar goods and services, you could be infringing on their rights, because by way of registration, they are granted rights to use that mark in association with those goods and services nationwide. So it doesn't matter if you haven't heard of them. It doesn't matter if they are based in Vancouver.
And they're not selling in your area.
It doesn't matter. They have rights across the entire country.
As of June 17th, we're going to be filing using the International Classification System. And that actually classes goods and services under 46 different class headings. So I've had this question a number of times. Well, that my client has this trademark that they're using in association with, for instance, gin. And they know that there's another company out there using that trademark in association with wine. Is that a problem? Michelle?
I would say that's a problem. The problem there lies in the fact that both of the goods for both marks are alcoholic beverages. They would both be sold within the same areas. In Ontario, that would be in the LCBO. So consumers could be confused as to the origin of the goods. So they could assume that the maker of the gin is the same maker of the wine.
Yeah. All right. So the importance of using a trademark agent or a trademark lawyer is to make sure that your application goes through seamlessly. It's important to get a search done to make sure that you're not infringing anybody else's rights.
If you want to protect your brand in the best possible way, you should definitely hire somebody who knows what they're doing. I know we all have the best intentions when we want to do things ourselves, and maybe, you don't think it's in your budget, or you think that it's easy enough to do on your own. But to spend the time working with somebody who knows what they're doing will pay off in the end.
It certainly saves you money, and just on that alone, when you're talking about budgeting, if you're a corporation and you file for trademark protection, the trademark is your asset. It's your reputation. It's a corporate asset, and therefore any legal expenses, which means our costs to protect, to seek registration for that, are covered as a legal expense and is completely deductible on your income tax return. It's just like hiring a lawyer to do your incorporation, or hiring an accountant to do your financial reports and everything. It's the same thing. When you hire a trademark agent or an IP agency to protect your rights in Canada, then it is tax deductible. Congratulations, Michelle. I'm so excited to have you as our newest registered agent with Pillar IP. Michelle works out of our Toronto office, so if you're in the Toronto area and you're looking for IP advice, contact Michelle at the Toronto office in the information that we've left below. Thanks for joining us for another episode of IP Somm. If you like what you saw here, please like, share, comment below, and subscribe to our channel. Remember, we're not giving legal advice here, we're just sipping and talking IP.